Thank you all very much for joining the session this afternoon. Hopefully you are all here ready and eager to gain your annual certification for California Fair Claims Handling. This training forms part of some of our regular RUA offerings. If you go to the Education Hub on our website, you can see there are a series of sessions that we've got ongoing at the moment throughout 24, and we'll be continuing into 25. Now, I am very pleased to say that we are joined by our expert trainers. If you've done the session with us before, you will already feel as if you know Andrea Best and Alex Spisak from MWE. Thank you both very much for taking the time to join us. And I know we'll probably hear a little bit more about it, but this is a very early start for Alex. So thank you very much for getting up to join us so early. Both Andrea and Alex will, of course, be taking us through the next 90 minutes towards certification. Before they do, I will mention just a few points of housekeeping to note down before we get started. And I should also say, if you don't know me, I'm Tom Hughes. I'm a senior underwriting and claims executive at the IUA. I look after a number of different class of business committees, including our aviation claims committee that essentially are responsible for coming up with this great idea to run the regular training. Now, we're hoping to have a little bit of interactivity as we move through the session. You'll probably all be familiar with the Zoom format by now, but you can post your questions via the Q&A facility that we'll be keeping an eye on throughout. And please do ask them as we go. There's quite a bit to get through, so often it's helpful to pick up the questions at the relevant slide. Now, we will be recording this session, and hopefully our event host, Tony, has already clicked go. We're ready to record. Now, in order to gain certification, you do need to attend one of these sessions live. The recording is just for attendees to check back on any details post-event, and that will also be supplemented by the presentation slides, which we will share post-event. Now, if you are dialing in via a phone rather than joining via the Zoom facility with your Zoom details, you'll need to let us know your phone number. And that's just so that we can match your attendance and make sure that you get the all-important certificate, which of course, the main reason that you're all here today. Now, dealing with the certificate, we will send that directly from IUA over the next couple of weeks. So just bear with us. There's quite a few certificates to get through, and we'll prepare those and then get those sent on with the approval of Andrea and Alex and the MWE team. Now, in order to let us know if you are dialing in via a phone, please email our events manager, Deborah Finch. Deborah has been sending you various emails about this event, so pick up one of those or just use deborah.finch@iua.co.uk. Any other issues or questions, please do just let either Deborah or myself know. Now, that's enough, and we can move on to the interesting side of things, and I can hand over, as always, with my sincere thanks to Alex and to Andrea to get us started. Thank you both very much.
Thank you, Tom. That was a great introduction. So for those of you who don't know me, I'm Andrea Best. I'm a partner in McDermott's London office, head of our regulatory practice here. And my focus is on US insurance regulation, hence this presentation. And my colleague, Alex, who, as Tom mentioned, is up very early for actually a trial in California. So Alex, I'll let you introduce yourself briefly.
Yeah, thank you, Andrea. I'm Alex Spisak. I'm based out of McDermott's DC office. I do insurance coverage litigation, and as Andrea mentioned, we're actually getting ready to start an insurance contribution trial in 2 days out here on the West Coast, related to some Superfund sites. So lots of action going on out here.
Excellent. All right, now thanks, Alex. We will, let me just scroll to just quickly the overview section. We will save some time at the end for some questions, but feel free to interrupt as we go along if you have any questions. If you are people able to actually, Tom, ask questions, or am I am I making that suggestion
They can ask questions via the Q&A
via the chat,
function.
of course, that's right. Okay, so yes, feel free to ask questions in the Q&A, and then we'll try and address them if we can. As I said, we'll save some time at the end for that as well. So this is just a brief overview of what we're gonna talk through, and Alex and I will alternate a bit just to try and make sure you don't fall asleep. So sorry, yeah. So with that, I'll get into the content. So why are we here, apart from the fact that we have to be, because California law says that anyone who is involved in handling California claims, including non-admitted insurers, need to have annual training certification. Well, there are a number of considerations to keep in mind for writing business in California and handling claims. So we've got, of course, wildfires just continuing year on year on year. And of course, the special scrutiny from the insurance regulators on how people are handling how insurance companies and adjusters are handling claims from victims of wildfires. Now, a couple of years ago, we had an election where we got a new insurance commissioner. California is one of, I think, 11 states where the insurance commissioner is elected. And his challenger asserted that he was not doing enough to protect people from wildfires and make sure that they have insurance coverage, that their claims are being paid, etc. And the allegation was that he was too favorable to industry. So of course he's definitely set on proving them wrong, which explains the department's continued preference to issue press releases and litigate over very high alleged penalties, which creates a momentum for claims handling complaints and reviews from the department. COVID-19 orders and requests, obviously that's a little bit more out of date now, but that is just once again proof that the department likes to reach out to. They were one of only a few states who reached out to insurers to say, what are you doing to treat your policyholders fairly? What have you done to reduce rates and make sure that people aren't being charged too much for their auto insurance premium if they're hardly driving anymore, things like that. And those surveys extended to non-admitted insurers, surplus lines insurers that are listed in California. So some of you may remember having to respond to those. And of course, as in many states in the US, California continues to have budget issues, which leads to the fact that if the California Department commences an investigation, it's potentially more likely that they'll be incentivized to try and maximize their penalties, right? Because they've spent the resources to investigate something. So, it's potentially difficult to resolve something without it leading to a penalty. So that's just kind of all of the,
Andrew, can I add one thing here? The California wildfires always catch attention because they're gigantic and catastrophic. But another thing to watch is there's just been weird, wild weather in California the last couple of years, ranging from atmospheric rivers that tend to come again and again and again, leading to major flooding. And then you contrast that in the winter, you have 10 to 20 feet of snow up in the mountains that then melt and create giant rivers themselves that do a lot of damage. And even a hurricane that hit Los Angeles a year or two ago. So I mean, it's truly been all over the place with California. So a lot of different types of claims. I think are going to be shifting focus as the weather continues to be all over the place.
Yes, thanks, Alex. That's a great reminder, and especially right now, I'm sure all of you are thinking very much about what's going on weather-wise in the U.S., albeit not California today. But yeah, that's of course always something to keep in mind when it comes to handling of claims and the practical background, right, that the regulators will be looking at when they're assessing insurer behavior. So again, this is just to this is from previous surveys of market conduct exams, right, that insurance regulators perform of as part of their their regular market conduct examinations of U.S. admitted insurance companies. And among the top 10 failures that those market conduct exams identified, so this is the regulators conducting the exam, was failure to acknowledge, pay, investigate, or deny claims within specified timeframes, failure to provide required compliant notices and disclosures in claims processing, failure to process total loss claims properly, failure to issue correct payments and or compliant denial notices, so like not pointing to the policy provision and properly explaining why a claim is denied, and improper or incomplete documentation of claims files, which we'll be talking a little bit more about that in a bit. So these are all important to to keep in mind, particularly when we're thinking of the long chain, often from yourselves in London to the claimant and all the different parties involved and who's doing what on your behalf, and making sure that these are all being properly handled. Because unlike the UK, where I think there's very prescriptive regulations around complaints handling, there's potentially less prescriptive detail around exactly how to respond to each stage of a claim and when, unlike California, which, as anyone who's attended this before will know, they have very, very precise rules. As I mentioned before, who do they apply to? So they do apply the rules, the regulations around fair claims handling do apply to non-admitted insurers, which includes surplus lines insurers. Certain types of insurance are exempted because they have other regulations that apply, which is workers' comp, which this market is not permitted to write anyway, at least not on a primary basis. Healthcare provider professional malpractice liability, again, they have their own rules, and self-insured or self-funded ERISA plans. Again, surety insurance also has separate regulations. And then some aspects of medical malpractice are no longer excluded, which we'll talk about that when we get to the very end. And then home protection contracts, which is kind of like a home warranty, California calls it a home protection contract, is now included under the regulations, because California, I think, is one of the few states that treats home protection contracts as almost akin to an insurance policy. Again, that's who it applies to in terms of what kinds of insurers and what lines of business, but in terms of what kinds of claims, there must be a California nexus. So it could be that the policy is issued to a California resident, as in a person or a company that's incorporated in California, or the claimant is from California, or the subject of the claim is located in California. So an accident occurred there, for example. It also applies to all persons who adjust California claims, settle California claims. And so that would, of course, include the local TPAs on the ground. And investigation includes all activities of an insurer or its claims agent related to the determination of coverage, liabilities, or loss or damage. So you can't say, oh, well, these regulations only apply to the local loss adjuster or the local attorney that I've appointed. This definition is broad enough to encompass what you all are doing sitting here in London. And then, as I said before, portions of the rules apply to insurance producers and admitted insurers, which are defined as licensees, claims agents of insurers, and the insurers themselves. Now, what the jurisdictional issues? So what's the California Department view is that, as I said, the regulations apply to all insurers, admitted and non-admitted. Some of you will recall that about 12 years ago, we had, instead of the current LASLI, list of approved surplus lines insurers in California, we had what was called the LESLI, the list of eligible surplus lines insurers. If a non-admitted insurer didn't comply, then the California Department would simply remove the insurer from the LESLI. Now, due to a change in federal law, the Non-Admitted and Reinsurance Reform Act 12 years ago, we now have the list of approved surplus lines insurers, which is voluntary, because any insurer that appears on the quarterly listing of the NAIC is automatically eligible under federal law to write surplus lines business in California. So arguably, the department no longer has authority to say, okay, you're kicked off the list, you can't write business in California. However, they do have the authority to issue fines. That is something the federal law, didn't, all the federal law says is that a state cannot prevent a surplus lines broker from placing business with an insurer that appears on the NAIC list. But of course, first of all, the NAIC itself now expressly has authority to oversee market conduct matters and governance matters with respect to the insurers on the NAIC list. And also the state regulators still have the authority to and do issue fines to surplus lines insurers from time to time. So training requirements, as I said, why are we here? All insurers, including non-admitted insurers, must adopt and communicate to their agents and their claims adjusters written standards for the prompt investigation and processing of claims. Individual licensees and third-party claims adjusters must annually certify that they have read and understand the regulations. And entity licensees, so that would be the adjusters or admitted insurers, must either provide training to their claims agents and certify annually to the training, or obtain a certificate from independent adjusters that they have been trained. And at least for admitted insurers, the annual certification has to be completed by the 1st of September each year and maintained indefinitely as proof that the training was done. For the general standards, insurers have to adopt and communicate written standards to their claims adjusters. And licensees, so the adjusters and the producers, have to have thorough knowledge of the regulations and provide thorough and adequate training to all claims handling employees and representatives. And the claims agents must promptly and correctly investigate and handle claims. This, we've listed here some of the four key areas of focus by the California Department. When they're investigating a claim, if somebody has made a complaint to the regulator about how an insurer is handling a claim, the first is faulty documentation, so namely the absence of communications, letters, notes, etc., any other essential information that substantiates the dates, the pertinent events, and the disposition of the claim. So if somebody has complained to the department that they didn't write to me, they didn't explain anything, they're saying this happened, but they provided no basis for that, etc. Improper handling, so that includes the failure to explain all the benefits and coverages available under the policy, as well as time limits that might apply for making a claim, and persisting to seek information that isn't required for or isn't material to resolving a claims dispute. So again, just basically not really acting in good faith. Improper delays in responding to communications from a claimant, which we see complaints for that a lot, of course, coming from the London market, because there's so many people involved in the chain. And improper handling of denied claims, so primarily stating in writing the factual and legal basis for the denial and telling claimants that they can appeal the decision to the CDI. So there's a legal requirement that you have to tell somebody, which we'll talk about in a bit. When you're denying the claim, you have to say, if you're not happy with this, you have the right to complain to the department. So if the insurer doesn't tell people that, that's a violation. Record keeping, you have to retain records for 5 years. They may be electronic if they can be duplicated to hard copy. I wonder how much longer that part of it is going to be retained. But it must be accessible, legible, and retrievable. There's an exception for catastrophes, but otherwise that's the case. claims file must contain all relevant information, which includes records, notes, including substance of all phone conversations. And you must be able to reconstruct the dates from the information that appears in the claims file.
Andrea, if I could add a little bit
Go
here, I
ahead.
mean, so my insurance coverage hat on, this is really, really important. You know, when things break down between an insurer and an insured, papering the file is really helpful in my position to be able to go back and see what happened and have a record in place to properly defend an insurer. So I can't stress enough the importance of keeping files in writing, keeping everything you have, all communications, all back and forth. If it's over the phone, put it in writing, kind of, you know, create an after the fact memo. It truly does make a big difference when there's a miscommunication, or if the CDI is going to come and ask a bunch of questions. If the file is well kept and well maintained and full of the useful information, it puts the insurer and the claims handlers in much better position.
Yeah, absolutely. Thanks for that, Alex. And the CDI definitely does want to see all your information, which we'll mention that later. Now, moving on to the initial interactions with an insured. So you must properly and fully represent the policy or policies to an insured. So i.e. the broker must properly and fully represent the policies to their clients. And you must disclose and volunteer, even if not asked, to all first-party claimants, all benefits, coverages, time limits, and other provisions that may apply. So that means that if there's a claim, you can't, and someone's made a claim under one section, you can't sort of think, oh, gee, they haven't thought of the fact that there's actually also coverage under this endorsement. I'm not going to mention that to them, but no, you have to. And also there's a requirement to conduct a thorough search for all applicable policies that may respond to a claim. Again, that's on the broker's interaction with the insured. Now, in terms of a notice of a release or a waiver. So, sorry, did I? Yeah. If an applicant is not represented by an attorney, which is called pro se in the US, and you seek a release beyond the subject matter of the claim, then you have to give a written explanation in terms of when they're waiving the claim, when you're settling it. The explanation has to be clear and conspicuous, and it should also be provided regardless of whether you think the claimant is represented by an attorney. So technically, this requirement only technically applies if they're not represented by an attorney, but you may not know if somebody's represented by an attorney or not. And it's best just to do that regardless.
Yeah, Andrea, there's this, I'll give my 2 cents here again. This is a big deal in California. They do not take violations of Section 1542 lightly. There's a whole string of cases, and a big one, Casey v. Proctor, where the court teed off on the insurer because they kind of settled a claim for next to nothing and caused an unrepresented plaintiff to waive all and every rights that he could have had. So it's not a good look. The California courts do not like it. So Section 1542 is a big deal to comply with. And as it says here, just do not try and hide the ball. Be very clear on what's being released and make it very apparent that it includes above and beyond what might be at issue.
Yes, absolutely. Thanks for that context, Alex. That's a really good point. And to that end, there is specific text required that needs to be included on the release, which we've listed here. A general release does not extend to claims that the creditor or releasing party does not know or suspect to exist in his or her favor at the time of executing the release, and that if known by him or her would have materially affected his or her settlement with the debtor or released party. So with that, I think, Alex, this is where you were going to kick off.
That's great. I'm up. So we're going to talk a little bit about deadlines. So this immediate 15-day rule kind of relates to claims handling, and effectively you must immediately transmit notice of a claim to the insurer, and let the claimant seeking coverage know that you've done so. And immediately, but no later than 15 days, we want to acknowledge receipt of notice or pay the claim, and that's accept disability policies. And as always, it's always best to keep the insurer in the loop so they kind of know what's going on as you're adjusting these claims. The notice may be in phone or in writing, as I've said before, and you'll hear repeated throughout this whole training, is the best practice is to put it in writing. That way it's easy to keep in the file. It's easy to keep it documented. And as Andrea mentioned before, is you need to be able to recreate timelines. Having detailed conversation of when the phone call happened, what was said, is helpful from that sense. And again, if you receive or respond by a notice by phone, put it in the file and provide necessary forms, instructions, and assistance as you're looking at these claims. Next slide, please, Andrea. So the statutory requirement 790034. This is information that must be provided as part of when you receive notice of a claim. So it's at least 10-point font. As it says right there, in addition to section 79003 of the insurance code, fair claim settlement practice regulations govern how insurance claims must be processed. It shows the individual where they can find this information and lets them know that they can receive a copy of this free of charge from their insurer. Next slide, please. So, like everything, there are exceptions to these deadlines to respond here, but there are two specific ones. So extraordinary circumstances beyond your control that would severely and materially affect the company's ability to conduct normal operations. So that is things that a truly major disruption, a total systems failure, something of catastrophic levels. Think about that hurricane that's about to come across the state of Florida. That would likely going to result in catastrophic circumstances beyond individuals' controls there. The other one is a notice of legal action by the claimant. So if the insured is filing suit against its insurer, that stops these deadlines to respond. Next slide, please. So what can a notice of claim look like? It can be verbal unless the policy requires it to be written. Again, it's the phone call example. You receive a call from an insured looking for coverage, that could count. Generally, you want it to include the date of loss, the time of loss, place of loss, name and address of the claimant and the insured, and a policy number. It's kind of that baseline information that can kind of help you begin the investigation process. There's no deadline to submit this info unless there is one in the policy. Next slide, thank you. Notice of a claim is pretty broadly defined, so it's any notification that reasonably apprises the insurer that the claimant wishes to make a claim. So it does not include communication for information or incidental reporting. So if inquiry is received, does my policy cover X, or how might this change my insurance? That's not necessarily a notice of a claim, but the best practice would be if you're not sure, or it could go either way, within 15 days. Let the insured or the claimant know you need additional information or clarification before you can process the claim. So kind of play that a little bit more liberally so that isn't a miscommunication. They think they're submitting a claim. You think it's a request for information. Seeking clarification or additional information on your end helps you meet the deadlines, while also then allowing the claimant to make clear, no, I'm submitting a claim. Here's the information you need. Excuse me, additional 15-day rule. So immediately, but no later than 15 calendar days, reply to communications that reasonably suggest a response is requested. Answer questions that are raised, provide forms or information an individual might be asking for or need, and provide reasonable assistance with whatever they might require. Commence an investigation if a claim is submitted, and you need to do that as a claims adjuster. And provide a copy of the insurance code section 790.03 and the additional regulations if requested. So we already talked about 790.034, which you have to provide. These are some additional ones that you may be required to as well. So there's a 21-day response rule. So if the California Department of Insurance comes around asking questions, you must respond immediately or within 21 days with a complete written response with known facts, including copies of requested documents. Again, here is where the importance of putting everything in writing in the claims file is really paramount. It helps meet this 21-day deadline. If you're trying to recreate the file or think about what happened in the past and it's not documented, it can lead into a bit of a fire drill. So it's again really important to keep everything in writing. If the request demands a shorter response time, you can try to seek an extension, but it might not be possible. So you want to try and comply with that deadline if you can. The request deadline is longer than the 21 days. You can generally rely on that, but it's always good to confirm in writing that the CDI will allow it to go beyond the 21 days because it is technically a violation if you miss that deadline.
Yes, and I will say from our experience these days, we don't ever really see the longer response deadlines, and that even if you follow up and say, we're still trying to find the information, or, you're asking us for information that we don't have, it's down there with the retail broker we don't talk to, or it's the premium finance company that we had nothing to do with, etc. The department comes back and says, nope, no extension. There's the law. I can't extend the law. That's it, 21 days or else. So, and what that also means, right, is that if you have written a response that makes sense, is well supported by facts and by what you think is the necessary documentation to prove your point, but the California Department the California Department inquiry letter asked for a whole bunch of other information that maybe is irrelevant, but of course they don't have the context for that. What this means is you don't get to decide, that's not relevant, and they don't actually need to see that to understand what happened here. I'm just going to provide them with the documents that make sense. Now, we've seen the department come back and say, thanks, yeah, your response, that all makes sense, understood. However, you still have a justified complaint against you because you didn't give me, the copy of the insured's application within 21 days, and I asked for it, notwithstanding that actually had nothing to do with the disputed issue, and so you didn't give it to them. That kind of thing, you really have to interpret it very literally, give them everything they've asked for within the 21 days. I will also add that just for context, what we're talking about here in terms of a CDI inquiry, this usually arises when a claimant has reached out to the department and said, I'm not happy, my claim's not being paid, or, I've been charged too much, or something, they've complained about something in terms of how they think that they've been treated unfairly, and they've reached out to the department for assistance. So the department has then contacted the insurer, the adjuster, the broker, all three, and said, please tell me your story within 21 days, right? So that's what we have to keep in mind. And sometimes these complaints are, don't make sense or have very little information. I've seen some in Spanish, where the department didn't translate, so you have to translate and figure out what is the person's issue. So, it's always important to just keep context in mind, when you're dealing with these kinds of regulatory inquiries.
Yeah, I think people use a lot of words to describe U.S. Government agencies, and reasonable is not usually one of them. So that's all right, Andrew.
All right.
Andrew.
Should I move on to the next slide? Or
yes, please. So 30-day response deadline. So within 40 days of receipt of a proof of claim, you must accept or deny the claim. Proof of claim is any evidence or documentation, regardless of how the you as the insurer obtained it, which provides any evidence of the claim and that supports the magnitude or the amount of the claimed loss, regardless of the source of the information. So as with the notice of claim, you want to kind of liberally construe this for starting the clock on this 40 days. If you cannot respond within 40 days, then you must notify that more time is needed and why more time is needed. Each 30-day kind of window thereafter, you must continue to do the same until a decision is made. One big thing, cannot require duplicative proofs of claim for multiple policies. Effectively, you don't want to make it seem as though you're making it difficult on the claimant to submit their claim. If it's can be done in one proof of claim, it needs to be done in one. Next slide, please, Andrea. Excuse me. If the insurer cannot make a determination until a future event occurs, provide notice that the determination cannot be made until then, and provide an estimate of when you believe that event will take place, and a determination will be made. So in the circumstances where there's a statute of limitations coming up, you must give notice that the statute of limitations is coming up. In fact, you can't use that upcoming deadline where the claim is barred as it used to string out negotiations and then deny a claim on that basis. And a 30-day deadline is a 30-day deadline for first party uninsured motorists. And if fraud is expected with a claim, the deadline is 80 days or more, as you need more time to kind of investigate and understand what is going on. A couple miscellaneous deadlines. So within 5 days, require written approval or reasons for denial of request of pre-authorization for non-emergency medical services. You cannot require pre-authorization for emergency services. I think that's pretty apparent why. And within 30 days after the initial notice that the insurer is contesting a claim under a disability policy, must affirm or deny the claim or notify the claimant that you need additional information or time. Excuse me, talking about settlement criteria. So no unreasonably low settlement offers, and there's 6 objective factors that apply. First is the extent to which the insurer considered evidence submitted by the claimant. So that is kind of looking at the whole picture in the file and what was received. The extent to which the insurer considered other reasonably available evidence or legal authority. So that then is kind of what additional information did the insurer gather and put in the file beyond what the claimant submitted, and how it kind of looked at that additional information that was gathered. The extent to which the insurer considered advice of the claims adjuster about an amount, and the extent to which the insurer considered advice of its claims counsel, the likelihood of success. So kind of beyond just the information that was gathered, how did the insurer rely on its hired counsel or claims adjuster, kind of that outside information and opinion. The extent to which the insurer considered probable liability of insured and likely jury verdict, and the procedures used in determining the dollar amount of property value. So it kind of looks at all the steps you take as you're evaluating and assessing a claim to determine if the settlement offer was unreasonably low. But there is also, next slide, thank you, a subjective factor, which anytime there's a reasonable person standard, it's kind of throws all those objective factors out the window. This is other credible evidence presented to the commission that demonstrates that any amount offered to a first party claimant not represented by counsel, or the final amount offered to a first party claimant to an insured who is represented by counsel, or the final amount offered to settle a third party claim is below the amount a reasonable person with knowledge of facts and circumstances would have offered in settlement. So at the end of the day, it kind of turns on that reasonable person standard, which can sometimes vary by the case, vary by the commissioner, vary by any whole number of factors at issue in play. So next slide, please. Settlement procedures. No worries. Go back one.
Oh, sorry, did I scroll too many?
Yep, all good. There we go. So you must advise first party of additional coverage and additional benefits. We kind of touched on earlier. The insured must know all the potential coverages or pieces of the policy that might be impacted by a claim. There's no deadline of an execution of a release, but the statute of limitations issue does apply here. The claim isn't really over till a release is signed and all that is done. So if they're sitting on a release and the statute of limitations is creeping up, those rules do have to apply. You do need to advise them of that. Waiver of unknown claims. We talked about this at length earlier. This is that section 1542. This is a big deal. It says no waiver unless a legal effect is explained in writing. You cannot require a polygraph unless it's authorized in the policy and by law. You cannot seek information not reasonably required for or material to resolution of a claim. use one proof of claim for multiple policies if a second one would be duplicative. Next slide, please. You can't deny a claim based on a telephone or personal interview unless it is documented in the file. Again, another instance where paper the file, keep documentation, put everything in writing. There's no recovery or offset of excessive or unnecessary medical benefits except for proven false or fraudulent claims. Medical examination is only based on good faith belief that such examination is reasonably necessary. No settlement contingent on status of complaint with the DOI. So in other words, you can't say, well, I will settle this claim with you if you withdraw your claim with the Department of Insurance. That is a no-go. You can't do that. And subrogation is only where appropriate. Must notify the first party claimant if a deductible is involved. Next slide, please. Again, subrogation demands must include first party claimant's deductible and must share recovery proportionally. If claimant has not recovered their full deductible, this does not apply to disability and health policies. Insurer is fully responsible for information, data, or statistical methods used by third parties. No black box defense. So especially you can't use information and then claim it's not your information. You don't really know what's going on over there if you're relying on it. You must consider any evidence or documentation that provides any evidence of the claim and that reasonably supports the magnitude of the loss. And you must provide notice to individual third-party claimants if settlement is paid to agent or representative. So effectively, once the money's wired or the check is cut, they need to be known it's out there. Next slide, please. So you cannot discriminate in claims handling. The standard categories protected classes: age, race, religion, gender, sexual orientation, ancestry, national origin, language, physical disability. Less obvious, we're in California, which tends to extend additional protections. It includes income and territory. It must conduct and diligently pursue a thorough, fair, and objective investigation and not request unnecessary information. So payment or denial of claims must tender payment within 30 days of affirming coverage of all or part of a first party undisputed amount and the execution of a properly executed release when necessary. 30 days is kind of the standard payment terms that you'll negotiate in releases, but they require it here. If a denial or rejection of claim must be in writing with the basis or bases for denial, include factual and legal basis for denial, must include policy provisions, exclusions, and or conditions relied upon, and an explanation of how the provisions apply. This is a big part of what I do. When claims are denied, we draft these very fulsome letters. It quotes policy language. It refers facts back to the policy language. These are not short letters. These are very, very detailed, and they need to be to kind of protect the insurer, lay out the reasoning. Because oftentimes, if as Andrea mentioned, some people their claim will be denied for a valid reason. They'll be upset about it and they'll run to the Department of Insurance and they'll complain about it. And that letter might be the first thing the insurance, the CDI sees. So it want that to be fulsome, thorough, explain why it happened, because if that's going to be the first impression the CDI has of this particular complaint. And if it's very clearly laid out, it kind of sets you off on a good foot when the CDI comes and starts to ask some questions.
I think, yes, exactly. Very, very good point, Alex. And I think it's also important, in my experience, for these denial letters to take into account who the audience is, right? If you're writing to a sophisticated commercial party that's represented by counsel, that's represented by a broker, and you know that, and you're dealing with them, that's one thing. If you're writing to a sole trader or just an individual person, for a personal lines policy, you have to kind of bear in mind that they may not understand all of the technical terms, and yes, you'd be issuing the letter via their broker, but just kind of keep in mind the fact that you want the letter to be clear and not full of jargon that an average person might not understand. And when they're looking at why is my claim actually being denied, because the more confusion that arises, the more of a chance that they might complain to the department if they think that they're being treated unfairly because they don't understand why their claim was denied.
Correct. Exactly right. I have one more. So this is the required language that needs to be in a denial letter. It just tells the insured or the claimant, if they feel their claim was wrongly denied, this is where they can reach out to for next steps. I think with that, we're back to you, Andrea.